Kay has been on criminal cases, and I don't do crime. She says virtuously. I do civil cases. Although I think there are some common issues, and what I've done in this is talk a little bit about the kind of work that I do, and then raise some procedural points and perhaps some questions that might be helpful if people think about and produce answers to. I'm at the Department of Statistics in the University of Warwick. My main line of work has been medical statistics. I've got long-standing collaborations in epilepsy and cerebral palsy, as well as some methodological research, and I've written about research ethics, which was amusingly relevant in the one case I've done that was nearly near to criminal. It was a professional misconduct hearing. So, I thought I'd just make a point about the background, about the difference between civil and criminal cases. Typically you've got one party claiming damages, occasionally actions from a second party. The actions will be things like, take that wall down, it's on my property. The question I was answering this morning, I wrote a report this morning from 6:20 to 8:50. Of course you have to time it because you're going to charge. I get asked, how long is this person likely to live? And that's can be people with cancer, cerebral palsy, which is brain injury at birth, traumatic brain injury, which is your industrial and motor accidents, and spinal cord injury similarly as well. So the highest individual personal settlement in the UK so far has been equivalent to 23 million for a young woman who was rendered tetraplegic in a road traffic accident. She's managed to carry on doing A-levels and go to university. I was a bit surprised by the settlement, looked up at what a life expectancy estimate I'd given, which was 58 years, and the expert for the other side I think had said 15 or 20 years. We had a rather nice one, when I say we, Sheila Bird, who once again has avoided listening to my talks. If anticoagulants had been administered sooner, my client would not have died. In fact, Sheila and I landed up, we were on the opposite sides, and we landed up writing an article about that, because in fact it's a classic problem in civil law and epidemiology, which is you may not have the data you want. A couple of other things I've got involved in. This drug damaged the sight of my patients, anti-epileptic drug, which involved a colleague here at the biostats unit as well, and the association of Vioxx with cardiovascular events, in which Merck claimed the weight of scientific evidence supported and continues to support that in a particular trial the comparator drug provided a cardioprotective effect, not that our drug increased cardiovascular events. There's no evidence, they said, that there's an increase in risk. Expert witness reports are usually for the court, but that usually is intentional, not the instructing solicitor. So what sort of challenges might you find? Well, I happen to be looking to check something about life expectancy of a child with cerebral palsy, and I came across this website, this is in the last month or so, and the claim was, although there have been no general studies of life expectancy in people with cerebral palsy, so on and so on. Okay, that was like the time I was giving a talk. It's part of either the Association of Victims of Medical Accidents or the Personal Injury Bar Association, and somebody was looking at life expectancy with cancer. Question you can ask yourself is, really? Really no studies? Remember, this is 2016. So, well, 1990, you might have thought by now they might have noticed something published over 25 years earlier. The second one actually is how, as with all of my career, it was terribly carefully planned. I got into this work by accident. Peter Farrow said, to get your career started, you want to apply for a little baby research grant to flag people with cerebral palsy, that is, find out when they die. And then when we published the paper, suddenly we became popular. And as you can see, there have been quite a number of other papers since then, up to 2014. Really no studies? In cancer, I found somebody giving a lecture saying how to estimate survival for cancer. That usually comes up if there's a misdiagnosis or something. And this particular doctor was relying on a data set from somewhere in Yorkshire of a few hundred people from maybe a couple of decades earlier. Didn't realize there are compulsory cancer registries which have data on survival. So for me, I think that's one of the big challenges for anybody in civil work is at the moment it's the clinicians who get asked, and typically I do mean clinicians, not even epidemiologists, and they may well have absolutely no idea that there is a lot of data there that is relevant. What other kind of interesting situations can you have, or do I have, I suppose, in particular? Well, it so happens that with life expectancy after neurological injuries, there seem to be two groups in the world that deal with this. One group is all of one person standing in front of you, and the other group is based in California. It's a commercial organization. Certainly several people write reports. They also publish articles, and one of their most recent claims is that the survival after spinal cord injury has not changed since the 1970s. And this is a table from their paper. There were a number of covariates, and I'm going to have fun deciding. Oh, it's that one, isn't it? So, a number of covariates, particularly the level of injury is one of the things that will be important. And they showed these results in 2006 article, and this is their update to 2015, and those are their results. So, let's take a vote. How many of you, having had a look at those numbers, and with apologies to any lawyers who feel I'm being unkind, how many of you think that you can categorically assert that there has been no improvement in survival when you realize these are the odds for death, and that 0.8 would mean you've got a 20% reduction in odds of dying per year? So let's have a vote. How many of you think you could be confident that there's no improvement? How many of you think there's a reasonably good case for improvement? Yeah, quite a few of you. Good. Yeah, well, okay, so for one thing, we've got a rather interesting grouping of the years. Why would you do your study periods like that? And what would happen if you actually combine those? Say you combine those two. We can do a very rough thing. 0.3, 0.5, so we average it as 0.4, and we say, ooh, if we double those, maybe we'll sort of halve the confidence interval very crudely, maybe not as much as that, but that would give us a significant effect. Well, as far as I'm concerned, this is one of the challenges I face, because the group tends to get known as Strauss, although I haven't put his name up on here. He was one of the original authors. They produced conclusions. There was no evidence of improvement. Long-term survival has not changed over the past 30 years. And I'm in the middle of writing a report. I mentioned to you before the case of Agnes Collier. It was in the public domain, which is why I can mention her name, where we had a discrepancy of about 15 or 20 years life expectancy versus my 58. They've just published a paper in 2015, and so asserted a whole lot of information, and I found one or two minor problems with their paper. If you don't work in medical statistics or medicine, you won't be familiar with things like these initial strobe. But in medical statistics, there are lots of checklists of how you ought to do research and how you ought to report it. And this is a checklist of items to be reported in cohort studies, and you can give yourself marks for everything you got right, and I think they would manage to get a score probably of 0 out of. For example, the original 50,000 plus patients became about 31,500 patients, but in table 1 they managed to represent a total of 67,000. And they make calm remarks like, for the 59% of patients with complete data, well, they have 5 exclusion criteria. Some of them are perfectly sensible, like you might choose which years you're going to study. You would typically, just as with birth, you would exclude the first year, because the first year almost invariably has a substantially increased risk of death, and nobody tends to bring a civil litigation case instantly. There'll always be a bit of delay, so your classic is that you have to condition on the person's current age. However, the other 2 missing covariates were the ones that I mentioned, what the severity of injury was and how complete it was. But they make no discussion, they just mention that they excluded people and make no discussion of that. Now, one of my methodological interests is precisely in what isn't there. In fact, as a statistician, I'm almost always interested in what isn't there. What people don't tell you, what they don't say. Sherlock Holmes made a point very forcibly about that in Silver Blaze. So they've told me nothing about why they've lost about 40% of their data. Well, that means they're assuming that that's missing completely at random. Do I believe that? No, particularly not in the US. In the UK, or even better, if you were in Scandinavia, well, you wouldn't have that amount of missing, but you're likely to have much better data. The US is a very big country with different states, and people are quite mobile. It's very difficult to track people in that situation. So, yes, I sent about 5-page letter of criticisms, and the initial response from my esteemed colleague David Strauss was to say that it would take him a long time to answer these questions, and so he'd like to charge the opposite side for his time. We didn't buy that one. If you're not doing things at the standard that's expected in your profession, you can hardly ask somebody else to pay you to do it. I haven't yet had the courage to look at his reply. One of the things he tends to do is be extremely vitriolic, which is one of the reasons, of course, I sometimes have difficulty in encouraging people to think of becoming expert witnesses. They have images. I don't have a television. They have images of people trying to bully them. I did once have the experience of a barrister trying to bully me. It was quite amusing. So what happens? As I say, that was their statement. If you actually do the standard medical statistician's meta-analysis trick on those odds ratios, so you go back onto the log scale and you do a inverse variance weighted mean, you do get a very substantial reduction in mortality, despite the published conclusion. It does say a certain amount, of course, about the quality of the journal in which the work was published.
Well, there was one thing in your initial presentation without the bottom line. It gave no indication, as you, I think, mentioned, about the ages of the people involved, how long they had been studied for, and things like that.
To be fair, that's because the table was very long.
Yes.
They did actually put age in.
Right.
In theory, they've properly centered. Actually, this is another issue, which is, again, great fun if you're explaining this in court, and mercifully, in civil cases, you don't have to explain it to a jury. They have asserted that the reason they use logistic regression to look at people who have lived to a certain date and then have actually known to have been died or censored, they say that logistic regression is better than an ordinary survival analysis model. And remember, I said this comment about having to condition on the age a person is. That's one of the classic issues in civil litigation with life expectancy. And I always thought it was a statistician's joke that clinicians and lawyers believe people would live forever. Because after all, the probability of my dying between this year and next year is less than a half, so on balance of probability I will live. Well, that was fine till I got a phone call last May on a Thursday afternoon saying, can we talk to you in an hour's time? And I said, no, but you can talk to me in 5 minutes' time. So they did, and they said, well, we're in court, we've got a case ongoing in court, and we have a problem with the evidence. Yes. When did you first hear of this deadline? So it turned out that it was a paediatrician giving life expectancy estimates for a very severely handicapped girl aged 10. And she'd looked at some of the Strauss publications, said, well, on balance of probability, he starts his estimates from age 15, but she's likely to live to age 15. And then from age 15, well, she's likely to live to age 30 from this table, and to age 45 from this table. Therefore, I'm going to estimate her life expectancy from age 45. So yes, I was flown over to Dublin. Mercifully, the judge was extremely sharp. I'd seen the transcripts and I saw that. As I say, I'm afraid, have a bit of a sense of humour. So there was the rather nice bit where, apart from explaining what was wrong with this and the correct approach, the unfortunate opposing barrister who was cross-examining me was trying to refer to a paper, so I had to be very polite and help him to find the paper and work out how to work the files, being completely angelic and watching the judge keeping a straight face. However, he then referred to something and said, do you accept this? Strauss has criticised this paper and said the method is completely wrong and you should be using a logistic regression model. And I'm afraid I had great delight in saying to the judge, because of course one replies to the judge, well, in fact, you will find on the paper to which we were just referring that Dr. Strauss has resiled from that opinion and has accepted that in fact he's doing a crude approximation to a log logistic accelerated life model. Again, the judge kept a straight face, knowing perfectly well I was saying to the barrister, would you like to play? He didn't want to play. Okay, that can be slightly unkind, of course. Sometimes you do have to explain what you're doing. But if you're unlucky, you will not get somebody who's really going to understand this problem of repeatedly increasing the age. Well, what might come up with, what are the other challenges in dealing with Vioxx? So I've been involved in 2 large cases that are about adverse effects of drugs. And with this one, of course, Vioxx, well, a lot of medical statisticians have heard about it because it was a non-steroidal anti-inflammatory drug that was very effective at what it was meant to do. It was to relieve pain. It also didn't have the adverse effect that it wasn't meant to have, which is bleeding, the stomach problems. Unfortunately, it was found to lead to quite substantially increased cardiovascular events, as in heart attacks and strokes. And there was a long history of the marketing people and the directors suppressing this information. The first line of argument was that in the main trial, Vigor, there was no evidence of an increase in cardiovascular events. The fact that the rate was much higher than in the control drug, naproxen, wasn't due to an increase in events, it was due to naproxen having a cardioprotective effect. Okay. There was no direct comparison of this, and only the verbal, no thrombotic cardiovascular risk associated with Vioxx observed in osteoarthritis trials. Similar rates of thrombotic cardiovascular events were found amongst those taking Vioxx, placebo, and comparator NSAIDs. Well, that's lovely, because of course what they're doing is they're playing the game of evidence of absence or absence of evidence. The reports that I was dealing with were conveniently not discussing whether there was good evidence of similarity or whether they hadn't really looked at it. So, of course, I would be expected to explain the concepts of statistical significance and confidence intervals, which I'm sure is something that's going to come up that we'll talk about. Contrary to the civil, we don't talk so much about likelihood ratios. So you have to explain all of that, and then you do a bit more digging. And of course, one of the games you can play is that, of course, the claimants say to the company, can we please have all the evidence? And the company goes, of course. and you get a room this size full of paper. Well, of course, you get the electronic equivalent. And so somebody is going to be playing games of working out what on earth it is you need to know. But I did actually read a selection of it. Subsequent studies provided further evidence of a cardioprotective effect of naproxen. A second clinical pharmacological study found that naproxen, at a certain dose, demonstrated a sustained antiplatelet effect indistinguishable of that from aspirin. It's not really surprising it was indistinguishable. They did a study on 9 healthy volunteers for 6 days. And again, I wouldn't necessarily expect lawyers to know the details of how drugs are licensed, but the European Medicines Agency, and FDA is probably similar, do have fairly clear, well-specified guidelines on what you have to do in order to claim a drug is equivalent. That's very important. If you've got epilepsy, anybody who has or knows somebody who has, you'll know that what you're tending to do is balance off your control of seizures against side effects. So very often a new drug, when you're trying to bring it onto market, and this was true of Vioxx, you're quite often trying to repeat the same effect, be at least as good as a current competitor, and reduce the side effects. If you're lucky, you'll get a better effect, but I do mean lucky. Which is why there is a very well-defined concept of equivalence and what you have to do to decide something is equivalent. And certainly 9 healthy volunteers is not going to cut any ice with any regulatory body. I was also amused, in the cynical sense, because I started doing more work with social sciences, and they're now discussing reproducibility and reliability, and they don't seem to have got very far with the concept at all of how you would decide something is equivalent. And again, that is quite a nice issue. If you have to take into account measurement error and natural variation between people, how would you do it? What do you do when confronted in court? They provided further arguments about this, of further evidence of a cardioprotective effect of naproxen. Well, actually, if you looked at it closely, naproxen's rates were higher than the other drug on the trial, and so you're going to have to do all sorts of interesting network analysis. So perhaps our colleagues doing the stochastic network analysis could enjoy themselves with this. But one of the other challenges for statisticians, this case was in Scotland, because ironically cases have been settled for billions elsewhere around the world, but of course each jurisdiction is separate. And nobody can afford to take on a pharmaceutical company as an individual. It's rather expensive. So you're reliant on legal aid. And for some reason, of the 200 or so cases in Scotland, the one that the Scottish Legal Aid Board decided to fund was not based on a heart attack. It was based on stroke, which meant that I had to then produce the evidence that related to stroke, which was considerably less detailed than heart attack. And I was helped even more by a meta-analysis which had cheerfully said that there wasn't evidence for an effect on stroke, which meant I then had to go through and do a detailed critique of the meta-analysis and explain why it was wrong and why you did in fact get an effect. So you can see why, as far as I'm concerned, one of the advantages of being a civil expert witness as opposed to a criminal is that you don't have to deal with a jury, and secondly, actually, you almost never go to court, you just deal with the lawyers. So the challenges for statisticians generally are the numeracy of lawyers and alternation between too little information, the data on anticoagulant administration. Frankly, neither Sheila Bird nor I could find anything decent to be able to say anything, so we had to, obviously the initial bit we weren't discussing, we came together to write the article afterwards. We rather disappointed the lawyers by saying, look, you can't draw any conclusions here. The one categorical conclusion we can tell you is you cannot say anything. On the other hand, the other pet game is too much information. Vigabatrin and visual field defect, it was 15 arch lever files. My technique with that is to say to the lawyers, you tell me what to read. I don't know whether lawyers here would appreciate why I would do that. I'm a very long in the tooth medical statistician. I know that if I read anything outside of what I meant to read, I'll probably find yet more mistakes. And I will in conscience have to mention that. Which is why I only read what I'm required to read. It also means, though, that sometimes I do what I'm not required to do. In the General Medical Council case, I was phoned up by a solicitor from the General Medical Council saying, we've got a case coming to court in 2 weeks' time, a professional hearing, and we realise we need a statistician. And okay, you're head of department and it's the middle of the final exam season, but would you do it? So I thought, well, I'm the only idiot in this country who would do it at that kind of notice. Ditto Vioxx, by the way. So I roped in a younger colleague and we did it. But what was interesting with that was, so now we're talking prosecution, I got instructions listing 10 charges against 3 doctors. I was asked to answer charges, I think, 8 and 9. But of course I read the whole thing and I realised the charges weren't valid. So of course, being obedient to the instructions I was given, I started my report by saying, in order to put my answers to my instructions to consider 8 and 9 in context, I need to discuss the others. Which meant that the case started with 9 out of 10 charges being dropped because they were just not valid. One of the challenges I think you very much have as a statistician sometimes is that you have what I call weaseling. You know the statisticians on the other side are playing silly games. They are not revealing the whole truth. They're saying, these 2 things were the same. Well, of course they were. We only looked at 9 patients. The life expectancy is an ongoing, as I say, as far as I can tell, there are 2 of us in the world who do this, and I get lots of very sarcastic remarks from my colleagues. Legal aid fees, is that a problem? I'll leave it up to you. The other interesting thing is the concept of property in a witness. In civil cases in Scotland and South Africa, there is property. And I'll say a little bit more about that in a little while. What are the advantages for the statistician? Well, the first one is exactly the same, the numeracy of lawyers. Most barristers I've met and most judges are extremely sharp. I have come across one judge who was not, but it was clear the case had only gone to court because, well, 2 judges, there's clearly a gamble on the quality of the judge, which paid off for the claimants. In England and Australia, you get a disclosure of expert reports. That's very helpful. You get joint statements of agreement and disagreement. And from my point of view, the big advantage is it's rare to have to go to court. I've probably done, I'm sure I should keep track, but about 300 cases. I've been in court in Dublin twice, but only given evidence once. Been caught in Durban, London and Melbourne, and then Manchester was GMC, which is not a lot really when you consider the number of cases I've done. Of course, you might be paid by insurance companies and they won't bat an eyelid too much. Although some of you might, with the discussions of insurance for motor cars, have noticed that a settlement of 23 million might, if people get worried about more cases like that and find the settlement's 23 million instead of the traditional 5 or 10, might possibly affect insurance premiums. And in England, there's no property in a witness. What do I mean by that? In Australia, the fact that you've given a statement to one side does not mean you're prevented from telling the rest of the world what you've said. Similarly in Canada, England, Wales, Northern Ireland, you're not allowed to put pressure on people not to liaise. Doesn't mean I haven't had a couple of lawyers trying that, but the one I sent an email back saying I thought there was no property in a witness phoned up and apologised immediately. The other lot said, no, we don't want to risk it. And when I asked some lawyers about this, they said, oh, that's fine. If you go to court, you just mustn't say anything about the report that you've written for side A if side B are talking to you. And I really wish that case had gone to court. I would have loved to have been confronted with that oath. Do you swear to tell the truth, the whole truth, and nothing but the truth? My lord, the lawyers have instructed me that I may not tell the truth. I'm not going to take this oath. I would have loved to do that. However, in Scotland there is property in a witness. The documents remain privileged and not disclosable even by the expert. So if there are only two people in the world, two groups in the world who do this, what is your strategy? You immediately instruct both of them and disclose the report you wish to disclose, which is what used to happen in Scotland. So side B approached me, and having not at that stage realised the difference in Scotland, I said, you know, if you provide me with information, I will write a report conditional on the information you have given me. Side A solicitor said, how dare you consult with the other side? So I, in fact, I think I said, but I have to check what the legal position is in Scotland. To which I said, I haven't, A, consulted, and B, if you do not trust me when I sign a declaration that my report is for the court, you shouldn't have instructed me. You've asked me to provide a report for the court. You've asked me to sign that as a correct statement, and now you're telling me you don't trust me. Well, they weren't too happy about that one, but side B said they wanted to talk to me with a solicitor from side A present about the report that side A had chosen to disclose. Well, it's not too difficult to communicate quite a lot of information if you're an academic without actually saying what you're not meant to say. And as far as I know, that was the last time that game was played. In fact, I've been told by one of the big groups up in Edinburgh, legal practices, that the side A now routinely just accepts my reports and respects them. But that is potentially quite a problem for, as far as I'm concerned, the law, and for statisticians. What do you do if you've, in good conscience, given an accurate report and you find the legal profession is trying to suppress them? So I'm sure the legal profession will be pleased to tell me all about that. In South Africa, the one case we were there, both sides were instructed, so myself and Strauss both gave evidence. Great thing about civil cases is you do get this exchange of information, except for Scotland, and it makes life an awful lot easier, particularly if you've got a colleague where you're both genuinely doing it and you don't have a colleague trying to distort the information. So one of the questions that I think arises is, who is an expert? So Sheila Bird has proposed for this workshop, and I think we'll take it forward. It would be very nice to have a list of which statisticians are active and what sort of work they do. I personally would like to encourage more statisticians to be experts in the civil side, because there's an awful lot of areas where I think we've got something valuable to contribute, and so I want a better understanding of the definition in different jurisdictions. In general, we want to be able to provide scientists, medics, solicitors, advocates, barristers, judges, some guidance on how to decide who's an expert, how to facilitate the presentation of evidence, and how to cross-examine. What are the ethical challenges? Telling the truth, or being allowed to tell the truth? I think at a social level, most countries face the challenge of getting good quality evidence because of the people, the shortage of people, particularly people who can communicate effectively, people who can assess expertise appropriately, and of course there's always the interesting question of what is a fair rate for fees. So I believe that statisticians can contribute to civil lawsuits by finding the evidence relevant to the particular case, evaluating it, and presenting it. The bit in green is not so visible because it's not necessary for this audience, but what I would tend to say to statisticians is, firstly, don't underestimate the value of simple statistics. I think this is true in civil and criminal. What is the quality of the data? What is missing? What are the simple summary statistics? You have to be patient and specific about what you're going to do, but I always recommend that people are quite generous in their estimates of the time needed and then claw back. And you often need to do telephone calls of explanations where people are reading a statement and they really need to have a discussion with you. So, that's the end.
Thank you
exactly on time, 5 minutes for questions.
I was interested by what you call property in the witness. First time I've heard of that was the few cases I've been involved in English courts. As an expert witness, you are called by the court, and although you may have come to the surface by being fished up by one side, you are not a servant of that side. You are a servant of the court. Therefore, you have to be able to disclose anything, whatever, to the court. Whereas the situation you describe, where one side or the other can put a lid on their witness, is totally contrary to that.
Yeah.
And it is also potentially a trap for the expert witness, because the expert witness, by virtue of limited information imposed by this system, may end up being in the wrong, and therefore could potentially be accused of misleading the court.
Okay, so the 2 points of property and the witness, the danger for the court and the danger for the expert witness if they're not given full information. Pretty well any expert witness will include a statement saying this is what I've assumed, and if the information changes, the report changes. Yes, I must confess I did get told a number of years ago which senior law lord in Scotland I should write to and comment on this, and I've never quite got round to it. I understand, are there any Scots who can tell me, that they are revising this?
I doubt it. There's a thing called precognition. There's the legal reason, as I understand it, for not is because if you have to disclose everything, you might discourage the lawyer from making any investigation whatsoever in case something is found prejudicial to the client. If you're listed as a witness, then you can be precognised by the opposition and you have to answer any questions that they ask. So the only reason you can't discuss it with the other side is if you were never listed as a witness in the first place.
So in civil cases they might not list their witnesses?
If you need to be on a
So
witness.
if I've written a formal report, there's no requirement for me to be listed as a witness?
Correct. And the reason for that is because it might discourage, what I've been advised, is that the reason for that is it might discourage, for example, in our work where you have a knife recovered from an assault, we frequently get asked, the solicitor says, could you do DNA and fingerprints on this, on the basis that we might find no fingerprints or DNA from the client. Of course, our advice always is that doesn't mean they didn't touch it, but nevertheless it can be supportive. However, if we did find fingerprints and DNA from the client, that report will never be served, and it's up to the Crown to do their own investigation.
So it is very much adversarial, but it does seem to me that if you're standing outside from the legal conventions, it's not obviously a good
Well, the
system.
lawyers obviously consider it a benefit that they can conduct inquiries they might not otherwise conduct.
The lawyers obviously consider it a benefit, yes.
It's very interesting talk, thank you.
Thank you.
There are different things going on here already. I think it's a good example of how there are considerable technical complexities about this. So the standard common law position is there's no property in a witness.
In England and Wales.
No, that's the standard common law position.
Does Scotland have common law?
They're not in this regard.
Yeah.
They're not standard, right? So, common lawyers will learn there is no property in a witness. Scottish position is different in terms of. That specifically relates to whether you can interview that witness, right? Now, that's different to whether you know about the existence of that witness.
Yeah.
Oh yeah.
It's a different thing.
Yeah.
So in England, there's no property in a witness, but if you don't tell the other side you've got a report, then they won't know. So it's not a question of what the technical legal position is. Now, the third thing in all of this is a question of privilege, right? And what Alan's talking about is some notion of work product privilege. And this is the idea that if the lawyers have generated expert advice as part of litigation, and that's privileged insofar as it constitutes first of all, the giving of legal advice, but secondly, strategizing about the trial as well. And that may, certainly in some jurisdictions, include discussions with experts, so that they effectively become the providers of privileged information. But here's just then there's a fourth thing, though. This goes back to, and I would have loved to be a fly on the wall in your imaginary court case when you didn't take the oath. That would have been fantastic. However, there's a difference here as well, it seems to me, and I'd be interested in your views on this. I'm not sure about this, but let me throw this out to you. There's a difference between you telling the truth as you see it and repeating the fact that you've already told that same truth to lawyers who have property in your witness statement.
Okay, but there's the whole truth bit of it. I might have been willing to take an oath to tell the truth in answer to whatever question I was asked and nothing but the truth, but I would not take an oath to tell the whole truth when I have written a report for the court.
But this is a question of relevance. That the whole truth is the whole truth of everything we know in the world, right?
No.
When you take the witness oath, you agree to tell the whole truth in response to the questions you were asked. If you were asked the question, have you prepared a report for the other side, then you would have been in a position to have to admit that.
I do not take the lawyer's view on that one. And, if a judge then was to instruct, if I said, I've been told I am not allowed to tell the truth about the report I have written for side A, and they said, well, that's fine, you're not allowed to tell the truth, then I would say, then I'm going to take a different oath. I'm not going to perjure myself. No, legally they mightn't think of it as perjury, but
I think we are talking about different things now.
Proposal. This is a very interesting discussion, which will be very suitable for the panel. I'll invite you to lead off in that, Paul. Thank you very much again.